A publishing contract is a legally binding agreement between the author and the publisher for the publisher to publish and distribute the author's work. The contract includes important details such as the duration of the contract, manner of publication and distribution, and royalties. It is a crucial document for both the author and the publisher as it includes expectations and duties of both parties. But why are contracts important? The contract defines each party's rights and responsibilities, such as the author's rights to their work and the publisher's rights to distribute and market the work. It also establishes payment structure for the author as well as how long it would take to publish. A well-drafted publishing contract helps to avoid misunderstanding and ensures that both the author and the publisher are clear about the terms of the agreement. As an author, signing a publishing contract can be a big step. It is very important to read all the clauses of the contract to negotiate the best possible deal for yourself. But what exactly does the contract cover? Firstly, it covers copyrights ownership and whether the author retains the rights to their book or grants it to the publisher. As an author, understanding this section is crucial as it determines how much control you have over your book. It also includes the percentage of royalties the author will receive from each book sale, when these payments will be made, how they will be transferred, and any tax deductions. The contract also includes the publisher's rights to distribute your book in the agreed upon formats and channels. It also includes the services that the publisher must provide, including editing, cover design, copyrights registration, ISBN provision, and marketing. Whichever services are listed in the contract, the publisher is required to deliver them. The author's responsibilities are also included, such as any information that they might need to provide or any applicable fees. The termination clause defines the conditions under which the contract might be ended. This includes the notice period required, the reasons that allow either party to terminate the agreement, and the consequences of doing so. It also defines which party is responsible in case there are claims doubting the accuracy or the originality in the book's content, as well as the violation of third-party rights in the book's content. A contract may also include information on book pricing, legal responsibilities, warranty, and other key details. Since a publishing contract can hugely impact your future earnings as an author, it is very important to read and understand every clause before signing. By being informed about all the terms of the contract, you can negotiate better deals for yourself and take control of your publishing journey. Do you have any more questions? Check out our other videos to stay updated about all things publishing. And you can also click on the link in the description to talk to one of our publishing consultants who will help clear all your doubts. Don't forget to subscribe and hit the bell icon for more updates. Happy publishing!